Yes, Mr. Holland.
Well, whilst this appeal raises an important issue, your Lordships will be pleased to hear it's quite a short one. Mr. Justice Foxton did two things. He terminated the appointment of Mr. Kei litigation firm, and he also required, the consequence of that, a personal affidavit of assets. And you can see that at the main bundle, page 101, paragraph 6. Where he required Mr. Kei personally and not via any intermediary swear and serve on the applicant's solicitors an affidavit setting out essentially his assets. There had been a previous order to serve an affidavit of assets on the 8th of October 2021. At that time, Mr. Kei's brother-in-law had just been appointed litigation friend. We needn't turn it up, but it's in the unagreed bundle at 195. And the brother-in-law swore the affidavit as litigation friend, and Mr. Kei didn't swear one. So Mr. Justice Foxton required a personal, not by an intermediary, affidavit of assets. What then happens is a serious and responsible attempt to comply with the Foxton order, notwithstanding the obvious problems. And in order to maximise the chance of being able to comply and to get an affidavit of assets from Mr. Kei, the help of Dr. Choi is enlisted as a person trusted by Mr. Kei, and because it was thought that with him there, that would maximise the chances. And we see what happens at page 58 in the core bundle, in Mr. Lin Hu's witness statement. You've probably seen this, we can take it fairly quickly. Paragraph 10 onwards, he explains in paragraphs 10 and 11, Mr. Lin Hu, the difficulties in taking instructions.
Well, he doesn't explain them. He asserts.
Well, it refers to, yes. That it's what comes afterwards, which is the key part. Paragraph 13, to mitigate some of the difficulties, in cooperation, he instructs Dr. Choi to assist. He was first of all asked to explain the day before the purpose of the meeting, and then to attend the meeting and assist. It was hoped that Dr. Choi, whom I understand Mr. Kei trusts, could reassure and calm him to facilitate in providing the affidavit.
Is Mr. Choi there in person? Dr. Choi there in person?
My understanding is that Lin Hu was in London, and Dr. Choi and Mr. Kei were together in Hong Kong, is my understanding.
It doesn't sound like that from paragraph 50.
Well, I think he was certain. I had understood that they were together in Hong Kong. It's possible I'm wrong on that. They were certainly both in Hong Kong. It is possible that Dr. Choi was separately in front of a camera. I had certainly thought that they were together. Well, if you look at 13, Dr. Choi was asked to attend little 2, to attend the meeting and to assist.
Yes, well,
I suppose it
wasn't a physical meeting so far as the solicitor was concerned.
No, it wasn't.
Attending the meeting is ambivalent in that respect.
Well, I can see that possibility, yes. It was hoped that he could reassure and calm Mr. Kei and facilitate him.
But if he wasn't there, obviously that raises the question: why wasn't he, and what would have happened if he was there?
Well, he was. I mean, this was a. There was no requirement for Dr. Choi to do it. We did this because we thought that would maximise the possibility of Mr. Kei being able to swear the affidavit.
There's no requirement that you rely on fresh evidence. So I'm not sure what's the answer to the point. The question is, if you say this is quality fresh evidence as to the position, then I think we're entitled to ask why Dr. Choi wasn't there, and why it isn't Dr. Choi who's made the statement.
Because I don't think anyone has so far suggested that this statement doesn't accurately reflect what happened. And what Lin Hu is doing is giving evidence about what happened at the meeting. So he was asked to explain the purpose the day before, so he had one communication the day before, and then to attend the meeting and to assist. So Kei was helped to sit in front of the camera by his assistants, asked Dr. Choi what Dr. Choi wanted him for. I greeted Mr. Kei.
That rather suggests that the purpose of the meeting hadn't been explained to him the previous day.
No, I don't think it does follow that, because the problems Mr. Kei is having as to the fact that someone had told him what the meeting was for the day before does not necessarily mean that he knew what the purpose of the meeting was the following day.
But we don't have evidence from Dr. Choi as to what happened the day before.
He recognised Dr. Choi and
Yes.
immediately asked him what Dr. Choi wanted him for. One would have thought that would have been part of the explanation the previous day if it had been.
Well, but that's, with respect, you're talking about somebody who is in control of the facility, of their faculties. I mean, it doesn't seem to follow. I wouldn't suggest it followed. That Dr. I mean, if Dr. Choi is asked to do it, there's absolutely no reason to think he didn't. He didn't do it. I greeted Mr. Kei, introduced myself. Before I could then explain the purpose, Mr. Kei asked Dr. Choi, why are they looking for me? What do they want from me? Do they want to harm me or arrest us? I don't want to hear any more. Is that okay? Choi then tried to explain the purpose of the meeting before he interrupted, asking Dr. Choi if they want to kill me. I tried to reassure them that we didn't want to kill him. I fear they want to kill me. Dr. Choi attempted to explain the purpose of the meeting. Mr. Kei looked to me increasingly agitated and unstable. Mr. Kei's assistants explained he was too unwell to carry on, and Dr. Choi suggested stopping the meeting. Mr. Kei left the call looking very agitated and helped away by his assistants. And then he points out that Dr. Choi and I have done everything possible to facilitate Mr. Kei swearing an affidavit as directed by the court. There have been great difficulties in receiving instructions. The process adopted in that call was specifically chosen to maximise the likelihood of compliance. Unfortunately, this hasn't been possible in light of its condition. So, I mean, that's the circumstances in which, I mean, it would have been perfectly possible, and indeed in the normal course, given that Lin Hu is in London and Mr. Kei is in Hong Kong, is that Lin Hu simply has a call with Mr. Kei and tries to get the information out of him directly. The whole purpose of getting the involvement of Dr. Choi is somebody who is known, I mean, who's seen him 40 times in the last 18 months or so, and who is known to be trusted, in a sense, by Mr. Kei. His involvement was there to facilitate it. And that was something which we did because we thought that would maximise the possibility of being able to achieve the objective.
Well, insofar as doing everything possible to facilitate Mr. Kei swearing an affidavit, the one thing he could have done was to have gone to see him in person with Dr. Choi.
Well, he's in.
And they could have sat around a table.
Well, yes,
rather
but
than staring at the camera.
Yes, but Mr. Lin Hu is in London and Mr. Kei is in Hong Kong. He's there with his assistants, and he's got the person who, as it were, he most trusts. I mean, one can always say one could have done something different. With great respect, this is, you know, we did it this way because we thought that was actually going out of simply what the order said, but would actually maximise the possibility of achieving the objective, and that's why we did it that way. It's with respect, it's a little unfair to criticise the fact that we went significantly beyond what we were required to do in order to try and comply with this. And
what he was obliged to do was what he was obliged to do was to swear an affidavit.
Yes.
Which meant taking instructions.
Yes.
Indeed, and it would have been presumably a very lengthy call, looking at documents.
Well, if an affidavit was, that was achieved, but they never really got past first base.
No, but presumably this was with a view to taking instructions to prepare a draft affidavit.
Yes. But it would have. It might have. When you say it was would have been a lengthy call. I mean, that would have depended on the content. I mean, it might have been lengthy. It might not. In fact, Mr. Kei is just about to be declared bankrupt in Hong Kong. So in terms of assets, and there's a hearing next week, as I understand it, when I think he would have been made bankrupt a few days ago, and there was some problem with the papers in Hong Kong, and he's anticipated he will be made bankrupt next week. So, I mean, exactly how much one just didn't get that far because he was, and that has been a consistent pattern, according to Dr. Choi's evidence, that he's hallucinating and he thinks his lawyers are going to kill him. And exactly what happened on this hearing was consistent with that, notwithstanding the involvement of Dr. Choi. So, in a sense, the consequence of the judge's order is, because it was served with a penal notice, Mr. Kei is potentially liable to contempt proceedings. That's not a purely hypothetical risk, because the claimants have already started 2 sets of contempt proceedings. They started proceedings for contempt in Hong Kong, which were where his wife acted as litigation friend, and those proceedings were ultimately compromised. This is the second set of contempt proceedings that the claimants have brought, and so the judge's order raises the question: well, what can we do? We are in the hugely unsatisfactory situation. The litigation is being conducted by somebody who's convinced that his lawyers are trying to kill him. And so what we did was, in efforts to do our best to comply, an affidavit was put in by the brother-in-law, the former litigation friend, in doing the best we could to comply with the affidavit of assets from in relation to the compliance with the Foxton order. So that's where we are. That's where the judge's order has left us. Let me just rewind a bit, if I may, as to how this has come about. 23rd of May this year, the claimant brought contempt proceedings against Mr. Kei. There are a variety of allegations. Can we look at supplemental bundle page 7? And one of those allegations, as you can see from page 7, this is the summary of facts relied on for the various contempt allegations. And if you look at allegation 6 on supplemental bundle page 8, supplemental bundle page 8, these are the grounds of committal. And paragraph 6, there is an allegation that Mr. Kei interfered with the administration of justice in causing or allowing...
Page 15 of the bundle, page 8 of the document. Is that what you're talking about?
Mine says page 8. Sorry. It's the...
My supplemental bundle
sorry.
has the first page of the contempt application notice at page 8.
Yeah. I was...
No, it doesn't matter. It's paragraph 6.
Yeah.
It's the grounds of committal.
On the grounds of committal.
Well, yes, you're quite right. I was actually looking at the formal document with it, but that's good. Paragraph 16 is good enough for this purpose, which is 6 of the grounds of committal.
Yeah.
First Respondent interfered with the administration of justice in causing or allowing to be filed. Form N235 stating he was a protected party and that he was a person who lacked capacity. In that he did not lack capacity, contents were false and known by him to be false. And it's said that the inference is that his purpose in causing or allowing the filing was to allow the asset disclosure required by the October order he'd sought and obtained to be provided by an individual other than the First Respondent, and to provide an ostensible basis to for any failure might be excused. Therefore, he's not had to participate in those proceedings personally. So, there are other allegations relating to the breach of the freezing order. The fact that he claimed that he lacked capacity and sought to rely upon the appointment of a litigation friend is said, and will be one of the grounds of contempt, as being an interference with the course of justice and therefore effectively a fraud. So that will be an issue in the contempt proceedings, which are we heard in March. Now, at the time of the
Sorry, just before we leave that document,
Yeah.
I noticed at paragraph 2 that one of the allegations of contempt was transfer from the UBS London accounts of specific sums,
Yes.
going all the way up to the 30th of December 2022, which I think is slightly longer in period than was referred to by the judge in his
Yes,
judgment.
I think what concerned the judge was what's really referred to as the UBS reports, the call reports, which go up to about April. I think the last significant one is 22nd of February. I think those were the particular.
Those are the ones the judge referred to.
Yes, I mean they're in.
But what my question to you
Yep.
is, did Mr Carey's second affidavit exhibit the documents on which that allegation was based?
He does in respect of most of them. Yes. I mean, there is he's set out the allegations in respect of the account. Yes. That I think. I think the reason that Mr. Justice Foxton, the judge, relied upon the UBS reports is the judge thought that was, if you like, prima facie evidence of involvement in his personal of Mr. Kei's personal finances, whereas the fact that money is being moved in terms. I mean, there is an explanation for all this. I mean, I'm sure it's highly contentious, but we've now put in evidence. I obviously can't rely on it today because it wouldn't comply with fresh evidence. But Mr. Justice Foxton was giving directions for evidence on the 7th of July. That's one of the things he did. And last month or so, we put in evidence in respect to that. We put in quite a lot of evidence about that. And there is an explanation about all this material. Now, as I said, I can't and don't seek to rely upon those explanations today because they were not before the judge. But there is now an explanation in respect of all those matters, and I suspect it'll be highly contentious.
Yes, but conversely, there was evidence before the judge, in addition to that which he relied on, that he was dealing with his financial affairs not just up to April, but right the way up until December 2020.
There was evidence that
subject to your point that the UBS documents don't constitute evidence.
But I think that there's yes. I mean, I think the judge thought that the importance of the UBS reports was that they, if I can put it from the judge's perspective, was that they prima facie appeared to show personal activity by Mr. Kei, whereas the transfers from the accounts, exactly what his involvement in was, perhaps might be more debatable. I suspect that's if one puts the, but there were transfers in 2022. So he was giving directions for the contempt hearing. We've now put the hearing is at the end of March. It was fixed for 2 days. The claimant has just asked to extend it for 3 days, having seen our evidence, and they haven't put in their reply evidence yet. They are due to do so in a matter of weeks, but they've asked for a 3rd day in respect to the contempt hearing. So I suspect there will be quite a lot of contention about what the explanation that we say from other witnesses is an explanation for what the documents show happened. So the evidence before the judge on the 7th of July, Dr. Choi, as you have seen, put in a report in August 2021. That was the first report he had put in. He'd put in previously, and that was relied upon in the, I think what the Milena friend calls self-certification in terms of the litigation friend, when the brother-in-law was appointed litigation friend in October 2021. And at that stage, Dr. Choi had seen, he had seen Mr. Kei, I think, for the first time in early August 2021. So when he did that report in August 2021, he'd seen him, I think, 3 times. In June 2023, he was asked to provide a report as to Mr. Kei's mental state as of the date of the report, by which stage he had effectively seen him something like 40 times. And I don't know if you've probably looked at what Dr. Choi says,
yes. But
you may see there's a CV appended, which, I mean, Dr. Choi is a very distinguished Hong Kong psychiatrist. I mean, one can see from his CV that, I mean, he is distinguished and very well respected. He's quite well known. The only other evidence before Mr. Justice Foxton was the evidence in support of the contempt application, in other words, Carey 2. So in effect, Mr. Justice Foxton was being asked prior to the submission of evidence on the contempt to consider what would be an issue which effectively would be one of the issues at the final contempt trial next year.
But do you suggest that he shouldn't have engaged on that exercise at all?
Well, I don't say he couldn't. I don't put it as high as that. There is an obvious concern about putting in evidence at an earlier interlocutory hearing on the very matters where the contempt is alleged, and in circumstances where the time for putting in that evidence has not arrived. What I would say is that it was a reasonable stance to take to rely upon an updated psychiatrist's report rather than at that stage to try and get into matters in detail of evidence where the evidence will be put in later. And that's how we would deal with that. What concerned...
But what's the relevance of that? If it was an exercise that the judge was properly undertaking, he had to undertake it on whatever evidence was before him.
Well, I think it goes to the question as to really at the heart of his decision is Dr. Choi was not shown the call reports, and therefore that undermines to an extent the reliability of his evidence. And I think that's essentially where the judge was. He said, on the face of it, there is material showing that Mr. Kei had command of his senses or his faculties in early 22, end of 21, 22. Dr. Choi hasn't engaged with that, and he hasn't been shown that. That's, I think, at the heart of where the judge's decision. The difficulty with that is that it's very hard to see how Dr. Choi could fairly have dealt with that. So it's very unclear to see what he would suppose. I mean, Dr. Choi is an expert, and these are matters of fact. And it's very hard to see how. I mean, first of all, is he asked to accept that those matters happened? Is he asked what an explanation for them is? And I mean, what is the premise on which he's going to be asked to deal with them? I mean, there are great difficulties with respect in a psychiatrist being asked to deal with matters of fact that are referred to in documents where there is no material to explain the documents, and where he is being asked effectively to make assumptions on matters that are likely to be matters of considerable controversy. And it's very hard to know exactly what he could usefully have said about them. I mean, he's seen Dr. Here you have a distinguished psychiatrist who's seen Mr. Kei 40 times. He's also, in his 2023 report, he also is supported in his views by the members of the family who he's talked to as well. And whilst he's reached his own independent views in that June 2023 report, he also refers to the fact that views from members of the family are consistent with his report. Now, there's a great difficulty with respect in an independent expert in being asked to engage with documents which have provided with no background in circumstances where what is he asked to assume? So we would respectfully suggest that actually asking him about them really at this stage causes more problems than solutions. I mean, one can quite understand at the final contempt hearing, when issue 6 relates to whether the purported appointment of a litigation friend was a fraud, then and where all the evidence is available to the judge, one can completely understand at that stage that Dr. Choi may well be asked questions about that, and whether, again, maybe on contested facts, how far that affects might affect his opinions. But it's very difficult to do it at this stage and to see how he could usefully have said anything about it. So that's the position where we are. I do emphasise that there are real difficulties in seeing how he usefully could have contributed to, if you like, the debate. So that's where we are. Now, I wonder if it's sensible in the light of that, as it were, almost introduction, to go to my skeleton and just take the various points from that. I think we start at, if you have page 6 of the main bundle, paragraph 17, which is capacity. Now, there's not much controversy here. No one suggests the judge got the test wrong, so I'll just deal with this very briefly. We've set out the provisions in respect to that, and referred to one or two cases, and no more than examples. Capacity is situation dependent, is the first point.
I'm sorry, where are we?
I'm so sorry. My skeleton, paragraph 17, which is the heading
yes.
Capacity.
Thank
you. Capacity is situation dependent. It's not does he have capacity, but does he have capacity to conduct proceedings? That's the first point. Secondly, many of the cases involve trials of question of capacity, although obviously this wasn't one of them. In many of these cases, there's actually evidence and cross-examination of experts as to capacity. The cases differ, but many of them are about some pretty fundamental moral issues. For example, capacity to conduct, there's one of them about capacity to conduct sexual relations. And there's another one about whether the mental state of the claimant in litigation in a personal injury case is such that they would can conduct the litigation because their mental state was such that they would be inclined to accept the first offer available and this was put under settle. Now, the other point that comes across in these cases is that although ultimately the decision is for the court, the importance of expert evidence is emphasised. Now, this is a rather different sort of case from most of those on two levels. First of all, it is an issue for contempt proceedings, and as I've indicated, issue 6 on the contempt is, was the use of litigation friend a fraud or interference with the course of justice? And that's the substantive issue. And secondly, the issue is raised by Mr. Justice Foxton's order. All that is really being sought here is can Mr. Kei have assistance in preparation for the contempt hearing by using his brother-in-law as a litigation friend? And given, I would suggest, it is obviously on the material available needed, it is an important matter. So it's different in that sense. So that's capacity.
Before we leave paragraph 17,
yeah.
Paragraph 17.1, where you set out the policy of the Act,
yes.
Is the word capacity in the second line an error for incapacity?
Sorry, 17.1.
17.1 on page 21 of the bundle. The policy of the Mental Capacity Act.
I'm so sorry. I've lost paragraph 17 of my skeleton.
I'm so sorry. I'm looking at the respondent skeleton. Okay. My fault. Sorry.
I'm glad any typos are on there. So that's 17. 22 to 23. Just in passing, I've made the point that the evidence relied upon, the issue in the contempt proceedings, and the issue to which the evidence goes, is whether Mr. Kei's actions in purporting to appoint litigation friend in October 21 was a fraud. That's all deal with in October 21. Now,
that's not, is it, the same issue as
it's not
Mr. Justice Foxton had to decide for the purposes of deciding whether he had capacity?
That's correct. So the evidence which was being led before Mr. Justice Foxton was evidence in support. Mr. Kei's affidavit was intended to support the main contempt, the only evidence in support of the main contempt, of the contempt application. And therefore what he was aiming at, as it were, was whether the appointment in October 21 was a fraud. That was the issue it was directed to. And he therefore puts in material which is late 21 and early 22.
Yes, but there's this distinction, isn't there? So far as the contempt proceedings are concerned, the thrust of the allegation is that Mr. Kei was dissembling. So far as Mr. Justice Foxton was concerned, he didn't need to conclude, and query he didn't conclude, that Mr. Kei had been dissembling in his presentation to Dr. Choi.
Yep.
He had to assess the totality of the evidence, including the fact that Dr. Choi's reports were rather thin on an explanation as to the functionality aspect of capacity.
He had to, and he was considering, and your Lordship is absolutely right, he wasn't reaching a conclusion as to whether he dissembled, he reached a conclusion as to whether he was satisfied on the balance of probabilities that as of July 2023, Mr. Kei had capacity. So to that extent, your Lordship is absolutely right. It was different. The evidence which was led in support of that was the only evidence led by the claimant, by the applicant, was evidence to show that he was dissembling in October 21. What Mr. Justice Foxton did was he inferred from the material put in for that purpose that, or he concluded that he wasn't satisfied that Mr. Kei had or lacked capacity in July 23. So to that extent, there is a difference between the two, but it meant there was no separate evidence from the claimant, from the applicant, as of July 23. And the only evidence directed to that was Dr. Choi, and Dr. Choi, having relied in his report, and it being a CPR compliant report, he not only relied upon his own opinions, but also having talked to those who surround Mr. Kei in terms of family and friends and supporters, and he's referred to those in his report as well. So
there's no suggestion, though, from Dr. Choi that there had been any significant change or deterioration in Mr. Kei's position.
That was one of the points the judge referred to, and he said, by this stage he has seen him 40 times, whereas in August 21 he barely knew him, as it were. So to this extent, by this time he's actually got a pretty detailed understanding of Mr. Kei and his shortcomings. And of course, when we get into the fresh evidence, it bears out exactly what Dr. Choi is saying, to this extent, that Dr. Choi is saying he hallucinates, he has persecution complexes, and he thinks his lawyers are trying to kill him. And that's exactly what happens at the meeting when Lin Hu tries to get an affidavit from Mr. Kei. He expressly refers to the fact that he's concerned the lawyers are trying to kill him. So so in our submission, this is obviously important litigation, these contempt proceedings. Potentially they could give rise to a custodial sentence. They are being conducted by somebody who will not give instructions to his lawyers, even if there is the potential of contempt, and who thinks the lawyers are trying to kill him. Just moving on in the skeleton, paragraph 29. And effectively, we make the point there, which I think is the point I just made, which is that effectively this is exactly in accordance with what Dr. Choi has been saying in his report. And I've also made the point at paragraph 33 as to this litigation is being directed by a person who hallucinates and has psychotic symptoms.
Well, the hallucinations were described as auditory, weren't they, in the reports? And the persecutory delusion was only, I think, well, it was not itself identified in the second report, although there is the reference at paragraph 28 of the second report to what was said whilst he was calling Mr Home waiting for a response. Asked me if his wife and her lawyers also wanted to kill him. Para 28.
Yes.
Page 80. That's so far as the evidence before Mr Justice Foxton was concerned, so far as the psychotic symptoms were concerned, that's all there was, wasn't there? Auditory hallucinations,
Well, so it starts... So
persecutory delusion unspecified, other than a reference at 28 to what was said when he was calling Mr Ho. Is that an unfair characterisation of,
I think
of
it's somewhat...
his evidence before Mr Justice Foxton?
I think it somewhat minimises them, if I may say so with respect. So if we just look at the paragraphs of Dr Choi, he first of all refers at paragraph 4 to his previous report. Then he explains that what he's done to do this. Paragraph 8, continually is stressed by multitudes of psychosocial stresses, limited improvement in his mental state despite of vigorous treatment provided. Depressed, strong feelings of hopelessness, believed someone was trying to persecute him, felt he was being followed as 9 and monitored whenever he tried to go out, socially withdrawn, troubled by poor sleep and nightmares, and then effectively his...
Well, none of that would interfere with his capacity to conduct proceedings, would it?
Well,
not obviously so.
Well, I'm not sure. Someone trying to persecute him, that's got to be tied in with the fact that he believed his lawyers were trying to persecute him.
Well, that's possibly a very important qualitative difference. If he needs to be able to engage with his lawyers in order to conduct the proceedings, then a delusional fear of persecution by the lawyers and that they might kill him is obviously directly relevant to that, neutrally. A fear of being followed doesn't, at least self-evidently.
Well, if you tie it together, I mean, 28, your Lordship's referred to already.
Yes.
30, then refers to medication. 32 is the severe depressive episode with psychotic symptoms. Unwell, clinically depressed, he's still exhibiting psychotic symptoms because of persecutory delusion. Suspiciousness in 33, irritability and delusional thoughts. So he refers to those. You've seen the report. I mean, that does not, with respect, that is not somebody who is capable of conducting proceedings on his own, as shown from what happened when there was an attempt to take a statement from him. But I mean, you've got the material. Your Lordship's got the material. I would suggest that the idea of somebody trying to conduct proceedings with those disabilities, with respect, is hugely difficult. And indeed, Dr. Choi, a distinguished psychiatrist that as he is being shown the definitions for the purpose of the Mental Capacity Act, as well as the requirements of expert evidence, when he makes that report. His conclusion, on the basis of what he said, and also what is the information he's obtained from others. He spoke to Mr Kei's wife, referred to there. 17 is also about sensitive, suspicious, and asked if anyone wanted to kill him. And 18, she dared not to mention anything related to his court cases in front of him. Mr Ho, 19 and 20. Mr Wu, again, persecution at paragraph 23. So it's all, he's talking to others in order to consider how far their view of their anecdotal reports are consistent with his own views, and effectively it's all more of the same. So that's Dr. Choi. If we go back to the skeleton, paragraph 35. And I think I've dealt with what we referred to as the first point, starting at paragraph 35, which is Dr. Choi and his evidence. I've dealt with that. At 41, refer to the call reports. Now, the claimant had not spoken to anybody at UBS. Mr. Kei, in his affidavit, it's apparent that he has not spoken. It doesn't suggest he's spoken to anyone about these documents. They are going to be an issue, no doubt, at the contempt proceedings. We've told the claimants that we expect them at those contempt proceedings to leave evidence about them. It is, as I said to my lord a few moments ago, given that at the hearing, Mr. Justice Foxton was giving directions for the contempt proceedings, and that we had put in Dr. Choi's evidence, it was not unreasonable in my submission not to put in evidence in response in relation to matters which are, on any view, a very considerable time earlier. I think I've already dealt with 42, which is the fact that...
Sorry, but I was having some difficulty with your assertion in paragraph 41 that Mr. Kei's second affidavit was deficient under the civil procedure rules in failing to identify his source of information and belief. He has an opening paragraph saying where matters are not within my own knowledge, I believe them to be true. He identifies how the documents were obtained from the UBS files. They are the sort of documents which one might expect to be in a bank's files as part of its regular handling of its client relations, and that's the source of his belief. What's wrong with that?
The point is simply that they are documents without any evidence to support them of any. He hasn't spoken to someone in relation to them. I appreciate it.
So what? So far as the requirements of the rules are concerned.
Well, this is simply a document without more, and he's seeking to rely upon that as a document without more, without actually having spoken to.
Well, they're bank records. Suppose what we were talking about were bank statements that have been obtained from the bank.
It's not quite the same with respect to a note of a meeting in respect of actually what happened to the circumstances. It's not quite the same as a record of whether money was paid in and out of the account. But I think the point is not. I'm not seeking to suggest that they are inadmissible, because I think that would be going too far. But the difficulty is relying too heavily in respect of them. And what he sought to do was to elevate documentation which raises an inference, and he would say a strong inference, as to the position, to the basis on which he terminated the appointment of a litigation
So
friend.
he gave them too much evidential weight in the absence of any evidence from the makers of the statement.
In circumstances where he had evidence from Dr. Choi. So, and as I've indicated, that's 41. 42 is I've made the point already about the difficulties in 42 too, about Dr. Choi, the difficulty of putting what effectively there is going to be quite a debate about to an expert, and the difficulty of actually asking him to make assumptions. That's 42. 43. We also, of course, there's the timing point that your lordships are aware of, that actually what the hearing before Mr. Justice Foxton was concerned with was the position as of July 23, and the evidence which the judge relied upon was evidence some time before. Now, and the only basis on which the judge really put the two together was, as my Lord Justice Phillips said, but Dr. Choi doesn't say that what's happened in 2023 is something quite different. He says effectively this is a continuation of the position was in 2021. And that was really the point made by the judge in respect of that. To which the response is, but actually, whatever Dr. Choi has now seen Mr. Kei 40 times and is able to provide a confident opinion in respect of it, and one ought to take into account that is the timing rather than something in the past. The remedial measures, just to point out, I'm sure the judge decided on this, is that he criticises in a sense. He said that Dr. Choi could have, in his report, asked whether remedial measures would have been possible. But the difficulty, and he was asked whether he had capacity, and he's explained in considerable detail his views in respect of that. So that I think deals with those points. I mean, in conclusion, just I think about 4 points. First of all,
but are you maintaining your submission that remedial measures are not relevant to the test as to capacity, even though that they're expressly referred to in the Act?
Well, no, I don't say they're not relevant, but I think it's again. I mean, Dr. Choi is saying. I mean, you might say that what was done in relation to the beginning of August was exactly the remedial measure, was attempting to take evidence with the assistance of Dr. Choi as well as the solicitor. Dr. Choi's, when Dr. Choi produced this report, there were no comments from the claimants in respect of it. They obviously didn't put in any evidence themselves in relation to it, or any expert evidence in relation to it. There was no...
Did Mr. Kei make himself available to be examined by a psychiatrist on their side?
Well, nobody suggested that before the 7th of July. No one asked before the 7th of July, when the hearing was for Mr. Justice Foxton, as to do that. And no questions were raised in correspondence about matters related to that. Dr. Choi was asked the question of capacity and has expressed a view. I think the remedial measures might be somewhat easier, and I indicated many of these cases are all about trials, where one actually has cross-examination of the experts about their reports and what could be done and how it could be handled and the like. I mean, here Dr. Choi has simply produced a report. He was asked to prepare a report in relation to the question of capacity, was shown all the relevant provisions, and has actually done exactly what he was asked to do, which was opine on the basis of his knowledge and examinations of Mr. Kei as to the capacity. I mean, it's pretty obvious from what is being said in Dr. Choi's report that he thought that there were huge difficulties for the reasons he gave in Dr. Choi running this litigation himself, or instructing lawyers and the like. And he's explained that. And it's very hard to see how he could have said anything helpful in relation to remedial measures. So that's that. I've made the point, and one says in the light of this, well, what is supposed to be done on Mr. Kei's behalf? I mean, this is not like one of those cases where, in terms of life and death, or sort of, I mean, the sort of huge moral questions that some of these cases are concerned about. The position here is that we are asking on behalf of Mr. Kei for assistance in preparing and dealing with lawyers in the run-up to some serious contempt proceedings which are taking place in March. And one asks rhetorically...
No, it's a little more than that, isn't it? One can have assistance without losing capacity.
Yeah,
you're asking it to be said that he cannot make the relevant decisions
absolutely
in relation
absolutely
to litigation.
Absolutely.
Not that he can do so, but with assistance. That he can't make the decisions.
Yes,
the decisions have to be made for him.
Your logic is right.
And that is qualitatively quite different, isn't it? From saying all we're asking is that he's allowed to have some assistance.
That's fair. I take that on board. I think the distinction I was trying to draw was between that and some of these, which are, raise some quite huge moral issues, and often after trial. Here, one wants the court's authority to be allowed in the run-up to and including the hearing in March, Mr Kei, the decisions to be taken on his behalf by a litigation firm. So that's what one asks, in a sense, if the court doesn't allow this appeal, what exactly are we supposed to do in respect to this regard? It does create huge difficulties in my submission, in circumstances where I use the word assistance, and your Lordship cavils at that, and I understand, where the decision-making process is done on his behalf, pending that. And in my submission, the fresh evidence really, it's obviously important, and indeed, Lord Justice Mayles, in giving leave, recognised the importance and said, particularly given its contempt proceedings, which of course they're important, and it's important that Mr Kei has and is seen to have a fair trial in circumstances where your Lordship has seen the position. So those are my submissions, and as I can assist you further.
Yeah, thank you. Mr McWilliams.
My Lords, subject to the court, I propose to structure my submissions in 5 parts. First, I propose to address the fresh evidence application and the reasons why we say it should be dismissed. Second, I'm going to take the court to some of the evidence that was before Mr Justice Foxton in July. Third, I'm going to briefly address the court on the statutory and procedural framework for the decision made by the learned judge. Fourth, I shall deal with my learned friend's ground of appeal. And fifth and finally, I shall pick up a couple of points made by my learned friend during the course of his submissions this morning. Turning first then to the fresh evidence application. In my respectful submission, the court should dismiss the fresh evidence application. It should do so for 4 principal reasons, summarised in my skeleton argument at paragraph 22 and following, which I'm going to develop orally this morning. First of all, contrary to my learned friend's submissions, the evidence Mr Howe gives is evidence that could, with reasonable diligence, have been put before the learned judge, and as such, the first Loudon Marshall requirement isn't met. And the justification given in the amended appellant's notice, Core 547, is that this evidence relates to matters which have occurred since the hearing on the 7th of July 2023, which have transpired as a result of trying to comply with the order under appeal. It's therefore paradigmatically evidence which could not have been obtained for use at the hearing at which the order was made. And the problem with that is that if one considers the specific evidence within Howe 3 on which reliance is actually placed, that's simply not the case. I could ask your Lordships to turn up Mr Howe's third witness statement at Core 7, page 56 and following. I can make that submission good by taking the court through what Mr Howe actually says in a little detail. The first 3 paragraphs are just the standard introductory material on which no specific reliance is placed. The 4th and 9th paragraphs merely explain the context for the evidence Mr Howe gives, and again are not specifically relied on as such. And the substantive evidence begins at paragraph 10 with the section headed Attempts to comply with paragraph 6 of the order. Now what Mr Howe actually says here, in the 4 paragraphs comprising this part of his evidence, of conceivable relevance to the decision made by the learned judge, is that 1, his firm has concerns as to how to approach the task of complying with the order because of the second Troy report, paragraph 10, and his firm has had difficulty in obtaining instructions to comply with the order, paragraph 11. I'm going to take those in turn. And Mr Howe plainly could have given evidence as to his firm's concerns before the learned judge. He knew the order that the learned judge was being invited to make by Hua She. He'd been in receipt of the application since 23rd of May, 6 weeks or so, and he had the second Troy report. Now, as to the difficulty in obtaining instructions, the salient point is that he's had difficulty in obtaining instructions full stop, not the particular instructions he was unable to get here. Now, that was evidence that could have been put before Mr Justice Foxton. All Mr Howe needed to do was to try and obtain instructions from Mr Kei before the hearing of the application. Done that, he would give effectively the same evidence as is now given after the fact. The evidence that Mr Howe gives, the justification for it, the explanation is why he's getting it is Mr Justice Foxton's order. But the real point of importance is that he can't get instructions from him, and he's concerned about things because the second Choi report, and that could have been done before the hearing. The next substantive part of Mr Howe's evidence is at paragraphs 14 to 17, under the heading "The Call on the 1st of August 2023, and it describes Mr Howe's attempt to obtain instructions from Mr Kei on the 1st of August 2023. And much the same point applies to this aspect of Mr Howe's evidence. Now, I of course accept that Mr Howe could not have given evidence of the particular call that took place on the 1st of August 2023. But again, the reasons I've given in my submission, that's not what matters for present purposes. Salient point is that Mr Howe was unable to obtain instructions, and that Mr Kei reacted badly to his attempt to do so. He could have attempted to do that before the hearing, and I don't understand to be any part of his evidence, or my learned friend's case, that the outcome would have been any different had he tried to do that before the hearing for Mr Justice Foxton. On the contrary, it must be their case that the same situation pertained as at the time of the hearing for Mr Justice Foxton. So the order
if Dr. Choi had given evidence about this conversation, it would have just been more of the same thing, wouldn't it?
Yes, my lord, yes.
That he had given in his previous report. So the question is, why is it different because it's Mr. Who giving evidence?
Indeed, it's less credible. The court has the evidence of a qualified psychiatrist whose credentials the learned judge doesn't doubt, describing pretty much the same thing a month before, less than a month before, on his examination.
Well, presumably the argument is that this is evidence that what was feared has come to pass, in that he was not in the event. It was not in the event possible, despite every best attempt and all precautions being taken to get meaningful instructions from him. That's what's being said, isn't it?
Well, yes. But again, that could be done because one can test the exercise, because Mr Howe at that point, with the benefit of the litigation friend still in place, can say, well, let's try and get some instructions from Mr Kei in response to this application. What does he say about what's being said by Mr Carey? And at that point, one could give very, very similar evidence, one would imagine, as to what's now given after the fact. It doesn't really matter what the reason for taking the instructions is. It's the fact that he can't get them, and when anyone tries to mention a lawyer, Mr Kei runs to the hills and has all of these problems. So it simply is evidence that could have been put before the court. Final two paragraphs of the witness statement just summarise his conclusion, summarise his position, and don't offer any further substantive evidence relevant to the question the court has to decide. So standing back then, in my submission, to the extent there's anything at all relevant by Mr Howe's evidence, it's Mr Kei's reaction when an attempt is made to take instructions from him. And on that point, there's no evidence that couldn't have been put before the learned judge. First ladder martial requirement isn't met, and that must weigh very heavily against the grant of the application made by my learned friend. Secondly, if it's being said that this evidence of essentially the effect, it's being said that evidence to the effect of Howe 3 could not have been obtained before the July hearing, because of the fact that the instructions were sought after the learned judge's order somehow matters, that's somehow significant, then that doesn't help my learned friend, because in that event...
Well, I suspect the point that's put against you is reasonable diligence didn't require it to be done prior to the hearing, because the position prior to the hearing was that he had a litigation friend, and Dr. Choi said he didn't have capacity, and unless and until that issue was resolved against him, it was reasonable for his solicitor not to seek to assume that it would go against him.
In my submission, reasonable diligence did require that evidence to be obtained. What they were faced with was an affidavit from Mr. Carey, which set out in great detail evidence from which an inference was drawn that actually Mr. Kei did have capacity, or certainly there wasn't good evidence that he didn't have capacity. And at that point, one of the things to be done, obviously, is to go and speak to Dr. Choi. But it's not an unreasonable request to make contact with Mr. Kei, the client himself, and see what his position is. That would be instructive anyway, to understand what the position was in answer to the evidence on which Hua She was relying, these call reports. It's perfectly reasonable. One would want to ask your client, well, what is the position about these documents? that would have been a useful exercise in and of itself, and it would have also been instructive in answering the capacity question. But on my second point, my lords, if it is said that it's somehow significant that it's after the event, then really this is evidence of circumstances occurring after the judgment. I set out in my skeleton argument that that's even less favourable terrain to learned friend than would ordinarily apply on an application to reduce fresh evidence under Ladd and Marshall. My third submission as to why the fresh evidence application should be dismissed is because, in my submission, there is no reason at all to suppose that the evidence in Howe 3, if given to the learned judge, would have made the slightest bit of difference. On the contrary, in my submission, this is a case where this court can be positively confident that it would not have made a difference. It can only be submitted that Howe 3 would have had an important influence if one can show either that there was no evidence at all to the effect of Howe 3 before the learned judge, and that it would have been important to the question the judge had to decide, such that you've had to engage with it carefully. Or that there was evidence to the effect of Howe 3 before the learned judge, but it would have redressed an evidential deficit on a particular point in an important way. Now, I've already taken the court through Mr Howe's evidence in Howe 3. The salient parts of that evidence are very short, namely that Mr Howe's had difficulty obtaining instructions, and that when he attempted to do so on 1st of August 2023, the effort had to be aborted after Mr Kei displayed some very strange behaviours. But the problem from a learned friend is that it was evidence to exactly the same effect before the learned judge. I've highlighted the relevant evidence in paragraph 25 from my skeleton argument, page 26 of the court bundle. And the evidence came in the form of the second Choi report of Dr. Choi, which we can see in the supplementary bundle at tab 6. First of all, if we turn to page 55, you can see at paragraph 7 and following, a section in which Dr. Choi records his views as to Mr. Kei's progress since his first report, dated the 19th of August 2021. And we see in paragraph 7 that Dr. Choi's observations are based on some 40 meetings between 10th of August 21 and 19th of June 2023. Paragraph 9, Dr. Choi records Mr. Kei's feelings of persecution of being followed and monitored. Paragraph 10, we're told that Mr. Kei's daily activities are now mainly taken care of by Mr. Ho, and Mr. Kei spent most of his time at home and refused to see anybody except his best friend Mr. Wu, and we're told that his visits to Dr. Choi were very short and he would be taken home immediately thereafter. Paragraph 11, Dr. Choi records, while Mr. Kei trusted Dr. Choi and was polite, not willing to talk, and would easily turn irritable whenever I tried to ask him questions related to his finance and legal cases. This is a thread that runs throughout the second Choi report. Next section of the report deals with observations from Mr. Kei's wife, Madame Zhu. Materially, paragraph 17, Madame Zhu records that he appeared to be very sensitive, suspicious, and repeatedly asked if there was anyone want to kill him. At paragraph 18, we're told that Madame Zhu doesn't even dare mention anything related to his court cases in front of him. Moving on, page 58, we have, starting at paragraph 25, Dr. Choi's observations of Mr. Kei at an examination conducted on the 19th of June 2023, not long before the hearing before Mr. Justice Foxton. Told that it was a scheduled appointment, that it was used as an opportunity to try and assess who was mentally fit to litigate. And I just asked the court to read from paragraphs 25 to 30, I'm sure it's material the court's already familiar with. So before the learned judge then was very recent evidence from Dr. Choi, qualified psychiatrist, who the learned judge considered to be an appropriately qualified psychiatrist, that paragraph 14 of his judgment, to the effect that one, the mere mention by Dr. Choi of Mr. Kei of his lawyer caused Mr. Kei to become agitated and emotional and to insist on leaving immediately. And two, Mr. Kei appeared to Dr. Choi to be clearly delusional and under the impression his lawyers were trying to kill him. It's evidence to pretty much the same effect as that given by Mr. Howe. Indeed, Dr. Choi's meeting with Mr. Kei on the 19th of June and the meeting on the 1st of August 2023 follow essentially the same pattern. Mr Kei is described in pretty much the same state, same sorts of words it used, same sort of remarks, and on both occasions the meetings are swiftly and immediately terminated when an attempt is made to discuss Mr Kei's legal issues. It's the same pattern. So standing back then, and returning to the two scenarios I posited a few minutes ago, the evidence Mr Howe gives is simply of a piece with Dr Choi's evidence that was before the court. So the only way it can be said that Mr Howe's evidence would probably have had an important influence on the result is therefore if it can be said that there was some evidential deficit on a point before the learned judge that Howe 3 would have addressed. And that's plainly not the case. The learned judge did not reject Dr Choi's report on this point, or doubt that it presented to Dr Choi as Dr Choi described. Rather, he made the decision that he did on the basis of that which Dr Choi had not been told, and therefore had not had a chance to consider in its assessment of Mr Choi's capacity, i.e. the positive evidence of capacity in the form of the EPS core reports.
So the judge formed his conclusion without having to conclude that Mr Kei had been dissembling towards Dr Choi.
Indeed, my lord, yes.
And then when we come to Mr Howe's evidence, do you say that that is to be explained on the basis that he was dissembling on that occasion? Or do you say, even if he wasn't dissembling, that would not evidence a lack of capacity?
In my submission, I don't need to say either, because it's Mr Kei's burden to prove a lack of capacity. The assumption is that there is capacity. One possibility is that he was dissembling. Indeed, that's an explanation for all of this. Indeed, it's the explanation that we think is the most likely. That's very much what Mr Kei says in a second affidavit. We have the First Choi report, and we look at the positive evidence of capacity, and we infer, well, actually, Mr Kei is not, in fact, ill.
Right. That's one. What's the other possibility that explains Mr Howe's evidence?
Well, the other possibility is that Mr Kei is presenting as described, but that doesn't itself mean that he lacks capacity. We can come to what that finding involves. But the mere fact that Mr Kei presents in that way doesn't mean that he lacks capacity. And I say, I can develop that as I take the court through the statutory and procedural framework.
But that would be, assuming that to be the case, that he's not dissembling Mr Howe, that is different from the position as it was dealt with by Mr Justice Foxton, whose decision did not have to assume dissembling. And referring to remedial measures, one might think plainly didn't assume dissembling. But if the evidence of Dr Howe is only consistent with a lack of capacity, if he is dissembling, it's only consistent with capacity if he is dissembling, then the evidence is of a different kind, isn't it? And might have made a difference.
In my submission, no. What one has in Dr Choi's report is evidence of his impressions of how Mr Kei presented to him over a series of meetings. And what one has in Mr Howe's evidence is how Mr Kei presented to him in a meeting. And in both documents, one has the same issue, that an attempt is made to engage with legal matters, firstly on the 19th of June 2023, and that causes the meeting to be abandoned. That's what Dr Choi records and isn't doubted by the judge. And then one has, on the 1st of August 2023, an attempt is made to discuss legal matters, and Mr Kei becomes agitated and leaves.
But if, perhaps you're going to come on to this, if there's no dissembling involved, and if the evidence that was already before Mr Justice Foxton was he couldn't engage with his lawyers, why didn't that then dictate the conclusion that there was a lack of capacity? to make the decisions which needed to be made for the conduct of the further litigation, including defending contempt proceedings?
Because all the evidence is in fact that an attempt is made to speak to him and the meeting is called off. Capacity is a finding that the court will only make, if I can put it this way, as a last resort. That's very much the structure of the Mental Capacity Act 2005. Everything should be done to allow an individual to have a role as possible, and you only conclude capacity if they can't make decisions for themselves. The fact they make bad decisions, do foolish things, it doesn't mean they lack capacity.
Right. And I entirely understand your submission, if I may say so, that on the evidence before Mr Justice Foxton, he was entitled to conclude that notwithstanding what Dr Choi had said, it didn't really go far enough to say he couldn't conduct the litigation by communicating with his lawyers when he needed to. Mr Howe's evidence is perhaps different if there's no dissembling, because there is an attempt to do the very thing that needs to be done in this litigation, and it's unsuccessful.
I take that point, my lord. There is a distinction, but it is if I may respectfully say, a relatively fine distinction when one is looking at the fundamental question the judge had to decide, and he had evidence to very, very similar effect, if not a real-life worked example of a lawyer trying to take instructions in the form of Dr Choi's report, because Dr Choi, as he says in his report, used to try the opportunity to try and assess if he's fit to litigate, and it has the same effect. What they describe it is exactly the same.
Well, is it? As I read Mr Justice Foxton, he wasn't persuaded that it was, and I can understand why. All there was in Dr Chu's earlier reports, there were some references to calling things off when lawyers were mentioned, and there's the reference to paragraph 28, but that doesn't itself establish that even if one takes those at face value and there's no dissembling, I can understand a decision that doesn't establish lack of capacity. But that isn't all the same as what Mr Howe describes, is it? I mean, it's a critical distinction, but it may be said it's a critical distinction that what Mr Howe describes is trying to get him to make the decisions which are necessary for the purposes of the litigation and failing to do so, if he's not dissembling.
My lord, yes.
And if that's right, then it isn't just more of the same, is it?
It is different on that analysis, my lord, but it is not radically so. It is a worked example of something which the learned, of something which, on one view, would have been apparent to the learned judge from Dr. Choi's report. We can see what he says there. He's got his Mr. Kei's wife saying that any mention of lawyers or finances, she doesn't even want to bring it up, and we've got Dr. Choi saying, despite having seen him for multiple occasions, the mention of lawyers means that they're already short meetings, have to be brought to an end. So it is different, but it's a worked example of something which was already there in the second Choi report, but which had to be pieced together. Except it does have to be pieced together.
Mr Justice Foxton's conclusion, as I understood it, was that he wasn't satisfied on the balanced probabilities that Mr Kei lacked virtual capacity to conduct litigation, even with the benefit of such remedial measures as might be put in place. Now, it seems to me that the remedial measures that might have been put into place include some quite obvious things, such as asking Mr Wu to be an intermediary for him in any meetings, the friend of 40 years, who he apparently is willing to speak to. That doesn't seem to have been done.
No.
And one might have done that in combination with meeting him in person in a relaxed setting, perhaps with Mr Wu present to smooth things over. So I don't see how this plonking Mr Kei in front of a camera and saying, right, we've got some questions for you, is undermines the judge's conclusions in any way. I can't see any remedial measures taken there
No, it doesn't
at all.
And that's the problem with one of the problems with Dr. Choi's reports, is that he does everything he needs to do on the diagnostic aspect. Yes, he's suffering from the condition, but doesn't then proceed to what are the implications of that. It's just an assertion. I therefore find he lacks capacity. Can't litigate. So there isn't an attempt to engage with those sorts of questions. And as my lord says,
Do you say that they should at least tried to use Mr. Wu as an intermediary?
well, yes, because
He's the one person who's been identified as somebody who Mr. Kei would speak to. Why wouldn't you use him?
indeed,
If he's willing, you'd want evidence, wouldn't you, that it wasn't possible to use him?
indeed, as I recall it, in the course of oral argument, Mr. Justice Foxton mooted all the sorts of measures that the courts take often in a criminal context to deal with very, very vulnerable defendants or witnesses. Those are all sorts of things that could have been done. But if one is going to get to that enormously significant conclusion that an individual lacks capacity...
I'm not sure quite what you mean by that. Those are in terms of giving evidence at the hearing. What we're concerned with is decision-making in the conduct of the litigation.
My lord, yes.
Which is broader.
It is broader, yes. It is. But before one can conclude, it's an extreme last resort that one lacks capacity. And you only get there if all other lesser measures have failed. And so what one needs to do to conclude a lack of capacity, such that this person can't actually make decisions in this litigation and someone else gets to do it for them.
But maybe that Mr. Kei would have given the power of attorney to Mr. Wu.
Indeed,
Or a series of questions could have been sent to Mr. Wu to go through with him, perhaps in the presence of Dr. Choi. Nothing was done here, as far as I can see, to make this easier, other than to bring him to a camera.
yes,
Apparently with Dr. Choi also on camera.
in precisely the setting that Dr. Choi's evidence would aggravate him. Here's your lawyer, he's got some questions for you, rather than indeed adopting those other courses. I mean, I'll come back to the test, if I may, shortly. But returning to the influence this evidence would have had, we can see in black and white the basis of the learned judge's decision, in particular in the Form N460, completed by him at tab 12 of the core bundle, where he states, the learned judge states in terms, on page 120, no legal dispute, issue over persuaded on the balance of probability that Mr. Kei lacked capacity to conduct litigation. The evidence I was not so persuaded. And A, we've got the contemporary documentary evidence. The call reports was not answered. And the psychiatric evidence not engaging in the material, which calls into serious question the information given to the expert. So in my submission, this evidence, this further evidence from Mr. Howe, just wouldn't have moved the dial for the learned judge because it wasn't what he was troubled by. And so for that reason, in my submission, the second ladder marshal requirement is not met. And that weighs heavily against the exercise of the court's discretion. That brings me to the fourth and final reason why we say this application should be dismissed, namely that the broader exercise of the court's discretion is obviously not confined to ladder marshal requirements. And we say that the claims made for the relevance of this evidence in Mr. Kei's skeleton argument aren't a sufficiently good reason to nevertheless allow...
Sorry, just go back briefly. Do you say that the two reasons which we have at 120, which relate to the documentary material, I'll use call reports as a shorthand, do you say that casts light on whether in the Howe conversation Mr. Kei was dissembling?
One moment. My lord, yes, I think it does, because one has evidence there that which called for an explanation, which wasn't answered and which still hasn't been answered in the purposes of this appeal.
Well, I read it saying that there's all this material which suggests somebody who's very capable of managing their affairs, and in discharging the burden of proof, showing the balance of probability, the lack of capacity, it's just not been done.
Yes.
And insofar as it said that Dr. Troy's reports do that, the immediate problem is he hasn't considered that material.
Indeed, and the learned judge proceeds on the basis Dr. Troy hasn't been shown them. That's the way he proceeds. Dr. Troy doesn't refer to them anywhere in his report, and it's got the standard declaration at the end of it, complying with CPR Part 35. And that's evidence which needs to be explained. So what Dr. Troy can say is, well, if those reports are genuine, then there's a psychiatric explanation for this, and here's how. He can still lack capacity to deal with his lawyers, but his bankers are less objectionable to him. I don't mean to be flippant, but that is what could be done by Dr. Troy in his second report. Or he can say, well, if that's right, then it would affect my conclusions, but I'm not in a position to conclude whether it's right or not. I can only go on the basis of my own observations. But there has to be some form of engaging with him so that the judge can then, engaging with that material, so that the judge can then form a view as to the issue before him. So on the broader claims for relevance, I think I've picked up some of these already. What's said is, well, that this is all important evidence that should be before this court, because it shows that Dr. Troy was correct. It's sort of the worked example, if I can put it that way, and that the order made by Mr. Justice Foxton is unworkable. We don't accept either. The fact that Mr. Kei was displaying the same behaviours to Mr. Howe after the order was made, as he did to Dr. Troy just before the order was made, doesn't take matters anywhere. Because the question before the learned judge wasn't whether Mr. Kei was displaying these behaviours at all. That wasn't doubted. But whether he in fact lacked capacity. And it's only possible to answer that question in the affirmative if the discrepancy between Mr. Kei's condition as described and the positive evidence of his capacity can be explained. And Howe 3 doesn't attempt to do that. And in any case, the question before Mr. Justice Foxton was whether or not Mr. Kei lacked capacity. Not whether his lawyers are able to, in fact, obtain instructions from him. Workability isn't the test. Obviously, it comes in the remedial measures point, but the question is, does he have capacity, not whether, when I try and take instructions, does on a particular occasion, does it work? So for all those reasons, in my submission, the court should refuse the fresh evidence application. And that, in my submission, is then enough to be the end of Mr. Kei's appeal, because there's no other basis suggesting that the learned judge erred in his approach, and it was an evaluative decision, and his evaluation is not one that can be fairly criticised. Brings me to my second topic, which is some of the documentary material before Mr. Justice Foxton. Now, the crucial evidence before him took three forms. We had the first Troy report, dated 19th of August 2021, second Troy report, 27th of June 2023, and then the material Hua She obtained from UBS by way of disclosure, given with the consent of Mr. Kei. Court's familiar with Dr. Troy's evidence, so I'm just going to take the court to some of the UBS documents, because they're documents which I'll be returning in my submissions later on. Very briefly, first thing to do is explain how we got them. My law will have seen the points taken by my learned friends in their skeleton argument as to their provenance and authenticity. But in my submission, they go nowhere. That's fully and credibly explained by Mr. Kei in his affidavit. We turn up to have 5 of the supplemental bundles. Page 25, we have Mr. Kei's second affidavit. That's the evidence which was relied on before the learned judge. Paragraph 37 following, Mr. Kei explains the disclosure sought from third parties by Hua She. And he says in paragraph 38, 2 charges registered against the title to a property in London in favour of UBS signed by Mr. Kei So we sought disclosure from UBS. To get that disclosure, we sought and obtained, amongst other things, Mr Kei's consent. And my Lord will see the consent. I don't think we can turn it up, but it's, my Lordship's note is unagreed bundle, tab 7, page 236. That's the consent actually being provided by Mr Kei, documents to be disclosed by UBS. Or one might wonder why consent would be provided if Mr Kei didn't accept that UBS were his bankers, that they would have some documents. He's providing his consent for his documents to be disclosed to us. With the benefit of that consent, the documents were then provided by UBS on the 22nd of March 2023. And we can see that unagreed page 245. That one probably is worth bringing up. Tab 7, 5.
Sorry.
245. This is a letter from Simmons & Simmons, who are solicitors for UBS. To those instructing me.
You mean page 245?
245.
Well, I think it's 457.
Yes,
It's probably 457.
It is 457, I'm sorry, it's bad reference, forgive me. Yes, 457. Where's the peril with the double?
Thank you.
And that notes that they've got consent from Donglen, who are obviously Mr Kei's solicitors. Paragraph 2, they've got necessary consent. Accordingly, we hereby disclose documents relating to Mr Kei's mortgage with UBS. The documents can be accessed at the following link. There's a share file link. It's been encrypted, password will follow. And then there's a bill. Over the page, we can see that the letter is copied to Zonglun, who are Mr Kei's solicitors. So that's where this UBS material comes from. We know what the universe of UBS documents are because it's defined at paragraph 42 of Mr Kei's second affidavit as the UBS documents. And at paragraph 48 of his second affidavit, he gives the evidence that comes from the UBS documents. So my submission has been perfect. There has been compliance with what the rules require. And this court can see very clearly where the evidence has come from, and it can obviously form a view as to the weight to be attached to it. But in that assessment, it's very difficult to see what could sensibly be said against it in circumstances where we have disclosure of documents from a bank with the consent given by Mr Kei's own lawyers. They've got the disclosure. You can see the documents because they've been given the same link so they can see what's being provided. What's being said? I mean, what more is needed in my submission? These documents to be treated as credible. Now, I just want to take you very briefly to some of the key UBS documents, because these are obviously important to the way the learned judge makes the decision he does. First of all, is the transfer request, which is dated 20th of July 2021, and the court can find that. I'm just going to get the right reference rather than the reference I've got.
Indeed,
my lord. Let me do it. So this is an email that's obviously on UBS's files. On the email, it's a letter, sorry. Instruction, transfer all my investments. This is UBS in London. And the court can see a little bit about how this document comes about over the page because we have the email chain to which it's attached. Clicking on 479, so I hope you're well. I understand you spoke with Anjali and Michael today. Anjali appears to be the client, Mr Kei's point of contact at UBS in London. We can make that good very briefly at 481. This is just one of the cash statements. What we'll see at the top of the page by the ring, binder holes, is the Kian Hung, your client advisor, Angeli Hong. So that's her. And so that's how this email comes about. So we've got emails and a document signed by Mr. Kei. Again, one would have thought that those emails could be looked at by Mr. Kei's.
You've got to link this up and have the date of the injunction.
My lord, it is after the injunction, which is early in July.
No, the injunction is 21st. 21st of July.
Was it? Beginning, yes. Sorry, it's 21st.
My understanding was that these emails were originally just before.
My lord,
then the instruction was confirmed.
My lord, that's quite right.
After the injunction.
Malena's friend's correct, and we can see that from 479. So the email is on the 20th. That's the instruction. Then we can see a further series of emails, 28th of July. And then this is on 478. Morning, Jeff. Client is signed and sent back.
I thought you made the point that it was telling that this exchange was the day before the injunction.
And it's confirmed.
Yes.
After exactly. Yes. So we've got the instruction. That's confirmed and goes back.
So I thought your point was that although we've got the date of the 20th at the bottom of page 477, in fact it was sent as per the top of 478 on the 28th.
That is indeed a further point. So on any view, the instruction itself, is the signed instruction, whatever the date it bears, goes back after the injunction.
It was actually sent.
Yes.
The instruction was actually given on the 28th after the injunction.
Yes, exactly. And that's what it's...
Albeit that it was in the form of a document which had been signed at an earlier date.
Indeed, but it's communicated after the injunction.
What Mr. Carey says, as I understand it, is it's highly unlikely to be a coincidence that Mr. Kei gave an instruction to UBS to transfer his assets out of the UK the day before he was served by the July order. I infer that the instruction was given in anticipation of the fact that enforcement steps might be taken in this jurisdiction and was an attempt by Mr. Kei to frustrate the same. Irrespective of his original intention, by the time he returned the signed instruction on the 28th, he was undoubtedly aware of the July order as he had contacted Zonggong and provided the materials to them as referred to above.
Oh, yes.
So that's your case.
That brings us to the first call report, which we have at 629 of the unagreed bundle. This is the 5th of November 2021. So again, for the chronology, the court will recall that Dr. Choi's first report is the 19th of August 2021. So we're now in the period post the first Choi report, where, and at a time when Mr. Kei now has a litigation friend. The attendees, the meeting as Mr. Kei, Angeli Hong and Melody Yeo, and it's a mortgage loan renewal fact find. We can see clients listed at the top, and we've got the total number of assets. And it's a follow-up call, so obviously there have been calls before that in regard to the Eaton Square mortgage renewal, supporting documents. And the client, so this is Mr. Kei, is clarifying his shareholding of assets and his plan of potential sales of One Hyde Park property. And he'll provide CAs with company documents, etc. next week. There's no suggestion that anyone else is on this call. And here we are, dealing with actually two assets that are expressly identified in the injunction made by Mr. Justice Knowles. And obviously it appears from this document that Mr. Kei is perfectly able to effectively explain to the bank what's happening to renew this very substantial facility.
It appears, though, that this seems to have been prepared many months after the call.
My lord, yes. All of the documents do have a date that is much later. I don't have an explanation for that. Over the page, we have a call, and this is not a call, sorry, a meeting. This is the most important for present purposes. A meeting on the 22nd of February 2022. So this one isn't a call over the telephone, but rather in person. We've got Mr Kei in London rather than in Hong Kong. So the attendees again, sorry, location first, top left. Client's house at 7A, New House, Eaton Square, London. Who's there? Mr Kei, Rahul Hegde, Angeli Hongspent, and Melody Liu. Rahul Hegde is believed to be a UBS person because one can see that from the contact detail. So this is a meeting to discuss the mortgage facility renewal and repayment. It's a £46.8 million mortgage facility expiring on 20th of April 2022. They're going to discuss that. And the notes give detail really of what Mr Kei is able to explain to UBS to support his application to renew this very substantial mortgage facility. So it records that his financial situation's changed, he's got liquidity issues. However, in Q2, Q3 2022, he has new business plans developments which will improve his liquidity situation. We've then got a series of events as what he plans to happen. He's got his cigars business, luxury watch business, he's got shares, and then we have a series of proposals that Mr Kei makes for what to do about the mortgage facility, the things he's doing. Over the page, he's put up One High Park apartment for sale, expects to fetch $8 million from the sale. The court will have picked up that Mr Kei said effectively he'd already sold that and it wasn't his, and so he didn't have a beneficial interest in One High Park in his asset disclosure. But here it is being said he's going to sell it and use the proceeds. Part of this evidence as to how he's going to refinance this facility. And thus the meeting concludes. And again, I obviously take my lord's point that the note is dated sometime later. But on any view, what this is recording is detail which must have come from Mr Kei, or certainly on this minute it did come from Mr Kei, in quite considerable detail, where Mr Kei is effectively able to make a business pitch without anyone else there, without Dr. Choi, about the very assets that are subject to the freezing injunction, with which he apparently can't give an explanation or give instructions as to his asset disclosure to his bankers. It is very, very difficult evidence indeed for any suggestion that Mr Kei lacks capacity. And again, we are here some months on from Dr. Choi's report, and this report here dates from time over which Dr. Choi has been seeing Mr Kei regularly, those 40 visits between 19th of August 21 and 19th of June 2023. Over the page, at 632, let's start at 633. There's an email from Melody Liu. You can see it's sent at 7th of March 2022. Angeli and I have just spoken to Mr Kei in regard to his marketing of One High Park. It may well be there's been a further conversation. And could you send us the marketing brochure? So what's happening here is they're just checking Mr Kei's homework about what he's told them at that meeting. I.e., I'm going to sell One High Park, so they want to see actually, well, is it up for sale? What's happening about it? This is good evidence that what happened at that time happened. And we have Mr. Windle's response on 632. Lovely talking to you yesterday. Here's the documents you requested. And if we go over the page, we can see the brochure for One High Park. And to similar effect, we've then got a further series of exchanges between UBS and Mr. Windle on 638 and 639. That then brings us to 646. This is April 2022. There's a call here on the 21st of April 2022, and they're actually informing him that...
I'm so sorry, I missed the page number. Where are we now?
646, my lord. Forgive me. This is the day after the facility's expired, and the bank's effectively giving him a courtesy call to say it's gone and we've sent you a reservation of rights letter. And they're going to speak to him again. And then there's a further call on the 8th of July on the following page. But in not one of these documents, we've got Mr. Kei, in regular contact over an extended period with his his designated client advisor. And she's the person who's making contact. And there is no suggestion internally on UBS's part that, hold on a second, we've got very real concerns about Mr Kei, or we're not sure about these instructions. On the contrary, we've just got perfectly ordinary minutes of calls, no cause for concern. And these are individuals that have met with Mr Kei personally and to whom he's pitched his ability to refinance. One final point, just that's my Lord's note. My Lord Justice Popplewell made reference to the payment on the 30th of December 2022. That is at page 570 of the bundle.
So, sorry, give me that page number again.
570, my Lord. See, Mr Kei, it's his address, client advisor, account name, Mr Kei. 19th of December, we've got money received from Mr Kei, some 489,000 odd, and then there is a debit to pay the mortgage. So the transfer, it's true, is coming in on the 19th. Mortgage one appears to be automatic. Direct debit to pay the mortgage.
Yes, I see.
So that's the evidence there. And again, this is the document that comes from UBS. Those are the documents then.
So there's a reference in the judgment to there being documentary evidence that Mr Kei came to London on the 20th of April.
Well, Lord, that is the core 20th April.
21st April call.
No, excuse me, my Lord. I think that is February. 1 second. The evidence, there's two bits of evidence on London. Check. So the meeting is in February. That's the call report. So he was definitely in London there. That's 6:30. I believe that the other visit to London is described in the second Choi report, because this is his Zoo's account, because he goes to London for his son's graduation. Yes, indeed. Yes, it's 57.
Sorry, 57.
7 of the supplementary bundle of Choice report.
What paragraph of the report? I've got it in the call bundle.
Forgive me, it is paragraph 16. This is May, so that's a visit in May, certainly. Just getting back to the judgment.
Agreed to attend the son's graduation ceremony. And then flew back on the 1st of June. No, that doesn't look as though that's the right reference.
But what the court will, of course, note is that there's no mention at all of the fact that Mr Kei went in February and obviously met with UBS. The suggestion that is being put forward here is you can only get him out of Hong Kong for something so important as his son's graduation, and he didn't.
This is a year, like this is 2023 now that's talking.
Yes, it is. But my Lord's right. It's not the. Let's get to the judgment.
Yes, this is a reference for what's in paragraph 23 of the judgment. Documentary evidence was on the 20th of April 2022. Mr Kei came to London to meet with bank officials there.
The only thing
And it's also an entry which I think is on Mr Hollander's schedule. So,
the only meeting I think I'm aware of is the February one. I think that must be an erroneous reference, because the only call report that is a meeting is I think the February one in London. No, well actually no, Mr Justice Foxton refers to That in the preceding paragraph.
Yes.
I wonder whether the mistake has arisen, because if you look at the first paragraph on 630, you will see he refers to the mortgage expiring on 20th of April 26.
Sorry.
Yeah.
6:30.
If you look at contact detail halfway down the page, you'll see there's a reference to mortgage facility expiring on 20th of April 22.
Yeah.
Now, I wonder whether the judge erroneously has got that date in there rather than the date of the call, which is 22nd of February.
Well, it's also referred to in the 21st of April call memo at 646. Notified the client the expiry of his mortgage facility, brackets 20th of April.
Yes.
But that's a mistake on your schedule as well, is it, Mr. Honda? Which is where I also see the reference to a meeting on the 20th of April.
It may well be.
We know there was a call on the 21st of April.
My Lord, yes, because we have that at 646, but it's not a meeting.
These are right.
So I think that is an error.
Thank you.
Turn then to briefly address the court on the statutory and procedural framework, because this is important for the decision the learned judge had to make and the criticisms my learned friend makes of it. The court's powers with regard to protected parties and the appointment of litigation friends are contained in CPR Part 21. CPR 21.2 provides that the protected party must have a litigation friend to conduct proceedings on their part. So if you're a protected party, you've got to have a litigation friend. There's no discretion about that. And CPR 21.12d provides that a protected party means a party who lacks capacity to conduct proceedings. CPR 21.12c in turn provides that lacks capacity means lacks capacity within the meaning of the Mental Capacity Act 2005. Now, the purposes and principles behind the Mental Capacity Act 2005 are very helpfully set out in black and white in section 1 of that act, which the court has behind tab 1 of the authorities bundle. To begin with, and most importantly, a person must be presumed to have capacity unless it is established that he lacks capacity. So that is the default position. It's a positive that you have to assume they have it unless it's shown that they don't. 3, and this comes in whether remedial measures are important. A person is not to be treated as unable to make a decision unless all practical steps to help him to do so have been taken without success. And again, that comes back to a point made by my Lord Justice Popplewell earlier about the reasonable evidence and the evidence that could have been put before the court at the hearing for Mr Justice Foxton. Attempts to try and do things and failing is one of the things that one would show. Or a person's not to be treated as unable to make a decision merely because he makes an unwise decision. And it doesn't matter that Mr Kei is going to do foolish things, the things that a sober-minded person would not do. That's not the test. He's free to make foolish decisions, but he just has to be able to make a decision. And before the act is done or decision is made, regard must be had, this is subsection 6, as to whether the purpose which is needed can effectively be achieved in a way that is less restrictive for the person's rights and freedom of action. So the policy of the Act then is to avoid concluding that incapacity is established unless after careful inquiry it's necessary to do so. It's not something that's done lightly, and that's because it substantially curtails the individual's right of action, given the authorities that summarise that tried proposition. It's Kingdom Right Roofing. Decision of Justice Kerr citing approval and observation to the same effect of Lord Mr Justice Burnett as he then was in VNR. Now, a person will lack capacity in relation to a matter for the purposes of the MCA 2005 and thus for the purposes of the CPR if at the material time they're unable to make a decision for themselves in relation to the matter because of an impairment of or disturbance in the functioning of the mind or brain. That's the first part, it's the diagnostic element. There's got to be something wrong with the functioning of your mind or brain. But the inability to make a decision about the conduct of proceedings is not by itself sufficient to make a person a protected party. So you have to have an inability to make a decision that's caused by an impairment or disturbance in functioning of mind or brain. That's the diagnostic test. And that can cover a whole range of problems like dementia, disability, or brain damage. Those are the sorts of things we often see.
Would you accept that the diagnosis that Dr. Choi came to of depression with severe psychotic, that is an impairment of or disturbance in the function of the brain?
My lord, yes. I don't quarrel with that. And neither did the Now, the assumption of capacity can only be overridden if the person concerned is assessed as lacking mental capacity to make a particular decision for themselves at the relevant time. Now, this is the functional test. We see that in section 3 of the Act on page 5 of the bundle. And the Act sets out quite a detailed formula for how one works out or assesses if a person is unable to make decisions. So section 3.1, so a person's unable to make a decision for himself, then unable, and it sets out the things that he's not able to do. Section 3.2, person's not to be regarded as unable to understand the information relevant to a decision if he's able to understand an explanation of it given to him in a way that is appropriate to his circumstances, using simple language, visual aids, or any other means. Again, this comes back to the point. It doesn't have to be that Mr. Kei can sit down in a room with his lawyers and give them line by line disclosure of his assets and give instructions in that way. That's not the test. If it can be done in another way that works, that's enough. And you can't find the person as unable, you can't make a finding, sorry, the person's unable to understand the information relevant to the decision. 3, it doesn't matter if you're unable to retain information for a very short period. It doesn't deprive you of an ability to make a decision. And if we just jump back to subsection 2, sorry, not subsection 2, section 2, on page 4, we see that in subsection 4, it's any question whether a person lacks capacity in the meaning act must be decided on the balance of probabilities. Above that, and again relevant in subsection 3, lack of capacity cannot be established merely by reference to the person's age or appearance, or B, a condition of his or an aspect of his behaviour which might lead others to make unjustified assumptions about his capacity. That's particularly pertinent here. Mr. Kei is displaying behaviours of concern, but one can't make an assumption of a lack of capacity merely by reason of that behaviour. What one has to do is one has to engage with the functional test that a person can't make decisions. And then we see that in subsection 2.1. So can you make a decision, even allowing for all of the limits on that decision that section 3 imposes? So the presumption that we have then of capacity is one that will only be displaced on the basis of proper evidence. And that evidence has got to deal with the diagnostic test, and I accept that Dr. Choi's report does deal with the diagnostic test. But it's also got to deal with the functional test. If you don't deal with the functional test, you can't make a finding that the person lacks capacity, because you haven't engaged with the question of whether or not he is unable to make decisions. And we can see the sorts of things that one has to do, summarised in the White Book commentary, which we have at tab 12 of the authorities bundle, on page 310. Starting at 2103. And at the very bottom paragraph, that page, 310, burdens on the person certain capacities lacking, evidence must be current, must then also deal with the functional test. And over the page, we see the authorities cited, which the court has in the bundle. I don't think there's any dispute on those authorities. Now, in considering the question of capacity, the court's got to consider all of the relevant evidence. And I fully accept, of course, as I must, that the opinion of an independently instructed expert will likely be of very considerable importance. That's precisely why one often produces an expert psychiatrist report, similar expert for this matter. But the roles of the expert in the court are distinct, and it's the court that's in the position to weigh the expert evidence against its findings on the other evidence. It's always the judge that makes the final decision. And the authorities in this context have stressed that. And for example, we can see a local authority in P, decision of Mr Justice Baker, at paragraph 15, what has that tab 5 of the authorities bundle.
We don't have tabs. Why don't have tabs?
Forgive me. The report starts at 92 of the authorities bundle. And the relevant, there's a summary then given, page 96. And the principles, which summarise many of the principles which I've taken this morning. But then at subparagraph 7 on page 97, court consider all relevant evidence. It's important, but the roles are distinct. And it's the court that makes the final decision. The final point to note about this, of course, is that a person can become a litigation friend pursuant to CPR 21.5 by filing a form N235 certificate of suitability. And that's what happened in this case, or by an order of the court. So there isn't a judicial consideration or an evaluation of the evidence of capacity. It doesn't have to be necessarily under CPR Part 21. So here what happened is the form is filed, it's filed by a litigation friend, there's the evidence of the first Troy report exhibited to it, but there hasn't been a judge considering that evidence and making a finding about capacity. It's just the appointment takes effect. That's then what I wanted to say about the framework of the judge's decision. And with that, I can turn fairly briefly to my learned friend's grounds of appeal and what we say about those. Before I deal with the individual grounds of appeal, I reiterate a point that I made earlier. That the question before the learned judge obviously was whether, on the evidence that was before him, he was satisfied that Mr Kei lacked capacity. And the learned judge considered the evidence before him, weighed it up, evaluated it, and concluded that he was not so satisfied. And any challenge to that evaluative decision, it was an evaluative decision, is one that faces a high hurdle. It's not enough for this court think that it will reach a different decision. One has to show that the decision the learned judge reached was wrong by reason of some identifiable flaw in his treatment of the question to be decided. Right, and you see that in sprint group, they don't need to turn up. And we say that's not a hurdle that can be surmounted in this case. Firstly, my learned friend says, well, the judge...
It slightly depends on what we do with the fresh evidence. If we don't admit the fresh evidence, then we have no more evidence than the judge did. And no doubt you are right on your submission in relation to sprint room. But suppose we think the fresh evidence does add something and should be admitted. What is the test we should apply in those circumstances?
I think the test one has to apply is whether or not the decision was correct in light of that evidence. One has to look at that evidence and the impact it would have had on the learned judge's reasoning, whether or not that renders that decision wrong in light of that evidence.
Thank you.
The first criticism made of Mr Justice Foxton is that the judge was wrong to depart from the conclusions reached in the second Troy report. But in my submission, this just proceeds from a false premise. It's not the judge to justify departing from the conclusion of the expert and to have to come up with good reasons for that. It's just a piece of evidence, an important piece of evidence nonetheless, but a piece of evidence that had to be weighed. He's not bound by the expert report, and what he had to decide was whether or not the evidence as a whole showed that he lacked capacity, having regard to that quite difficult test that he had to meet under the MCA 2005. So it's not decisive. And in my submission, the judge was entitled not to accept the evidence of Dr. Choi, notwithstanding the fact it had not been controverted. Obviously referring my skeleton argument decision of the Court of Appeal in Griffiths and Turi, that was superseded last week by the decision of the Supreme Court. In my submission, it doesn't really affect the point at issue here. The decision of the Supreme Court, we've got it in the bundle, is really a point on the rule of Brown and Dunn, in that there was cross-examination. The expert was there, it wasn't put to the expert. submissions that were then going to be made, and then it's a point that goes to the fairness of the trial. And that's what the Supreme Court decided. It wasn't a fair trial because you didn't put these things that you were going to say about the expert witness. And just as that would be the position if you didn't put something to a witness of fact, the position is the same for an expert witness. It doesn't change the position that ultimately the question is, in this context, is one for the judge to be satisfied. There wasn't cross-examination, and no one was making findings, adverse findings about Dr. Choi as such. It's simply that, well, he wasn't showing this material, and so the weight I'm going to attach to it is correspondingly lower. For all those reasons, in my submission, it's not whether he should have departed, it's whether he was entitled to reach the conclusion on the evidence before him. And in my submission, the learned judge was entitled to conclude that he wasn't satisfied that the test had been met for showing lack of capacity. There was substantial evidence, and I've taken the court to that this morning, that showed that Mr Kei, for a large period where he was said to have lacked capacity, that he actually been able to take complex decisions for himself. He'd given instructions and explanations to his private bankers. And that evidence obviously militated against the conclusion Dr. Choi reached. He wasn't told about it, and he couldn't consider that in reaching his conclusion. Still less offer a medical explanation for it, of the kind, obviously, that the learned judge was after. Now, while the positive evidence on which Hua She relied in relation to Mr Kei's capacity only really runs up to the middle of 2022, the point that the learned judge made in his judgment, in my respect, submission was right to do so, is that Dr. Choi had seen Mr Kei repeatedly over this whole period. And there's no evidence Dr. Choi doesn't say that there'd been any material improvement in Mr Kei's capacity over this time. There's no suggestion that he rebounded remarkably after in early 2022, and then things went badly again for him. There's nothing like that at all. Rather, the picture that Dr. Choi paints is one of pretty much consistent picture. There's sort of some mild improvement, but it's not suggested that he actually positively regained capacity anymore. And Dr. Choi's inability to detect the same on the basis of examinations of Mr Kei during this time does call into question his later conclusion in June 2023 that Mr Kei continues to lack capacity. The other problem with Dr. Choi's report is it just doesn't engage with the functional limit of the test. And my learned friend says, well, it's very fulsome, but he just states he lacks capacity within the meaning of the Act as a conclusion, but he doesn't justify that by applying his mind to his ability to make decisions for himself. So the report is deficient in that respect, and that's really the fundamental question that needs to be engaged with and isn't engaged with in either report. Next, my learned friend says, well, Mr. Justice Foxton was wrong to replace the reliance he did on the call reports. I've already addressed the court on how those reports came to be disclosed. In my submission, they're plainly evidence to which the judge was entitled to have regard, particularly so in circumstances where there was no explanation offered, or contrary explanation, or basis for suggesting that they were forged or faked or somehow incomplete. We've got disclosure that's provided by Mr Kei's own bankers pursuant to his own consent, recording him taking steps with regard to a property. It's hard to see why those reports would be inaccurate. Now, my learned friend says, oh, well, the learned judge drew inappropriate support from the well-known judgment of Mr Justice Leggett, as he done was in Guessman. But the simple and correct point being made by the learned judge was that Mr Kei's criticism, and there was no evidence from the individuals at the EBS who produced the call reports, only goes so far in circumstances where any dispute primarily would ordinarily, forgive me, it only goes so far in circumstances where any dispute about those call reports would ordinarily be resolved by reference to the call reports themselves, because they're the contemporaneous document, rather than the recollection of...
Well, not necessarily some of them on the normally contemporaneous documents.
True, no,
Just months or years later.
But they are more contemporaneous, certainly, than a witness giving oral evidence about those meetings at the current point would be.
yes, but that may not make them any more reliable.
My lord. Now, my learned friend says, well, the reason it's not fair, really, effectively, to take my failure to answer the call reports on the basis that it had been prejudicial to require evidence to require him to file evidence on the same given the overlap. But in my submission, that's just a decision for him to make. They're separate applications, and it's a matter for Mr Kei to decide what evidence to lead in answer to each application.
The judge says in paragraph 25 of his judgment that following the Mr Carey's deployment of the UBS materials, that was the context in which Dr Choi was approached to produce a second report. And then the next paragraph, it has been confirmed that Dr Choi was not provided with or made aware of that material. Where does one see those two things?
So the confirmation, I recall, was given by my learned friend orally, but it's in the course of submission. Indeed, I'm grateful to my learned friend. And the other aspect is in Dr Choi's report itself.
Where he says what he saw.
Indeed. Just give me 1 second. The Choi report, paragraph 5, says it's produced to update his latest mental condition. But there's no suggestion in the document that he's been provided with anything from UBS.
Well, 6.
Indeed.
6 probably identifies what it is that he's relying on, doesn't it?
Exactly, and then a paragraph, the declaration at the end obviously contains the usual confirmation. But certainly the chronology of this report is that Mr Carey makes his affidavit and his application on the 23rd of May. This report is the 27th of June. It is immediately obtained and then deployed for the purposes of the hearing of the application on the 7th of July. That's what it comes into being for. And that's indeed what's so bizarre about Dr Choi's second report. The whole purpose of it being adduced, the court doesn't need an update. There's no order requiring an update about capacity. It's being sought to answer the criticisms made in Carey too, but Dr Choi isn't apparently told what those criticisms are or engage them. He just simply repeats his conclusion again.
Well, in his first report, Dr Choi said, judging from his current mental conditions and likely he could follow evidence and give instructions in court, not that it required mental capacity to give instructions. That was in August 2021.
Yes.
You would think that he'd be asked to review that opinion in the light of page 630 of the unagreed bundle.
Yes.
That's your point.
Indeed. That's the whole reason they're going to him, is because they want to put it in front of Mr Justice Foxton and say, don't worry about all those call reports because we've still got psychiatric evidence that says he doesn't have capacity, but they don't tell the expert, or appear to tell the expert, why he's being asked what he's being asked. Now, that brings me on to my learned friend's third point, which is, well, the learned judge placed a lot of reliance on the fact that the call reports hadn't been shown to Dr Choi. And he says that it was unfair to criticise the fact that had happened. We say that it's bizarre that they weren't shown to him because they were the genesis for the report he was being asked to write. And they were evidence that could and should have been provided to Dr Choi. Dr Choi, in his report, he's got not just his examinations, but he's got anecdotes and impressions from Mr Kei's wife, from his friend, from his assistant. And Dr Choi obviously thinks those are important because he records them in his report. Those are all things that he then takes into account along with his examination on the 19th of June, informing the decision that he does and conclusion that he does. But Dr. Choi isn't confining himself just to, if I can put it this way, a purely medical examination. He's looking at the matter in the round. So in my submission, it's quite hard to see why it's inappropriate, or it's appropriate for Dr. Choi to have regard to the helpful bits of information relating to Dr. Choi's, Mr. Kei's capacity, in the form of these anecdotes from friends and family, but not appropriate for him to have regard to other evidence in the form of the call reports. Now, in my submission, he could have considered that evidence, even allowing for the fact that there may well be points about its provenance. Because what he can say is, well, I've been provided with these documents. I'm told that there's concerns about their provenance or whether or not they're correct. And he could then offer an opinion on the basis that if those reports are accurate, this is what I consider to be its implications, if any, for my diagnosis. Does it affect the diagnosis? Would it have any effect? And that would have been very powerful and helpful evidence for the learned judge. Is there a reason, an explanation as to how Mr. Kei can still lack capacity, notwithstanding the fact he was telling what he was telling to the UBS over this period, that works? That's what the judge wanted. And that's something that Dr. Choi could usefully have done. I've already dealt with the call reports, and then the final point is the judge's reliance on the fact that Dr. Choi's report didn't discuss remedial measures. Well, in my submission, that is a serious failing in Dr. Choi's report, because it goes to the very heart of the question that he was supposed to be answering, whether he lacked capacity. Can he make the decisions? And he doesn't address his mind to the test. He really just he deals with the diagnosis and then says, well, he therefore lacks capacity.
Can you help me with what sort of remedial measures might have assisted in a case like this? Assuming that Mr. Kei is not dissembling.
Well, there may well be something, a question on which Dr. Choi himself would have been able to assist from his own medical experience. But, for example, what does appear to be the case from the evidence, and again, assuming he's not dissembling, is that the trigger is lawyers. That is what brings to an end the meeting Dr. Choi has with Mr. Kei on the 19th of June. That's what brings to an end the 1st of August meeting. Dr. Choi's been happily meeting, albeit for relatively short periods over an extended period, 40 times. He's able to meet with him, he's able to assess his condition and to diagnose him and to prescribe medication for him. And indeed it appears that Mr. Kei is still seeing his friend and his assistant is helping him. That's on the basis of the evidence, assuming it's correct. So one obvious answer would be that one removes the triggering contact between Mr. Kei and his lawyers, and that instructions are taken not by his lawyers, but by others.
Thank you.
That's one example. No doubt there may be more, and that's precisely where Dr. Choi could have assisted the court had he addressed his mind to the test, because he would have been able to say, well, these are the sorts of things you could do, but I don't think these will work for Mr. Kei for X, Y, Z reasons, or this might work. And then you would have evidence of, well, we've tried this, because this might work, and it didn't work. But we don't have anything like that. So for all those reasons, in my respectful submission, the learned judge's decision was correct, and it should stand. Unless I can assist the court further, those are my submissions.
Mr. Horton.
I made some submissions about capacity. Can we just look at the Mental Capacity Act in the beginning of the authority? So the key issue on section 2 2.1, the first tab, section 2.1 of the 2005 Act. The court has that. For the purposes of this Act, a person lacks capacity in relation to a matter. At the material time, he's unable to make a decision for himself in relation to the matter. So the question here is, the decisions which are in issue here are the conduct of this litigation. That involves engaging with lawyers on key matters, decisions regarding instructions, settling, how to deal with it, strategy, and so forth. So and dealing with those day-to-day matters that are all part of conducting litigation. So the question is, can he make decisions for himself in relation to that? And when you go back to section 1, and Leonard Friend referred to remedial measures, that is in the previous page, in 1.3, he's not to be treated unless all practical steps to help him to do so have been taken without success. So the practical steps, the remedial measures, are to enable the Mr Kei to conduct litigation himself and to take the decisions himself, not through somebody else, in relation to that. Because if somebody else is taking the decisions, then that's the whole point of the litigation friend. So the question is whether those decisions can be taken by himself. And obviously there's a variety of decisions to be taken, but I mean, I think I mentioned, you don't need to turn to it because it's only an example, the case in the bundle King and Wright Roofing. The concern there on a personal injury claimant was that because of the fragility, if you like, of the claimant's mental state, he was not capable of exercising independent judgment in making a decision to settle. That was the key issue. There was a concern that he'd take too little money, grab at any settlement. And therefore the purpose of a litigation friend was to take those decisions for him objectively in his own interest. So that's the capacity issue the court is concerned with. Now, my Lord Justice Phillips said, well, couldn't the exercise that was done at the beginning of August have been done with the assistance of Mr Wu? First point to make is if you look at the order that's being made, that was made by the judge at page, I think I've got it at 101, first thing I showed the court. The provision of information requirement at paragraph 6 of Justice Foxton's order is to make the affidavit personally and not via any intermediary. Now, so he has to do it himself and not via an intermediary.
Well, that's the end result. That doesn't say anything about the process.
Well, I see that, but with great respect, one can always say, well, couldn't Mr X or Mr Y have helped Mr Z? I mean, the whole point. I mean, it's you've seen the evidence about the process that was adopted to try and do this in a way that was thought to give the absolute maximum possibility of being able to do it, and it was for that purpose that the exercise was done in that way. And as Lin Hu makes clear in his witness statement, it was done with the involvement of Mr Kei's assistant TS, as opposed to in the sense that he says at paragraph 11 of his witness statement, he'd been trying to arrange a meeting with Mr Kei directly with the help of his assistants. And he also says that he was helped at the meeting to sit in front of the camera by his assistants. So in that sense, he actually had not only Dr. Choi there to give him the assistance that I've already referred the court to, but he also was assisted at the meeting by those who were assisting him. Now, it is true that Lin Hu doesn't specify which ones of his assistants were there, but this was not a position where Mr Kei is there on his own and the only person apart from Lin Hu who is there on this arrangement is Dr. Choi. Mr Kei is being assisted by other people as well. Now, with great respect, I mean, that is, in terms of reasonable steps to comply, and in terms of how one deals with it, it's hard. You know, none of this was suggested to us. This was done on behalf of Mr Kei in order to provide the maximum chance of being able to comply with the order, and it was done that way. And with greatest respect, it's not really for after the event to say, well, something different could have been done. There's no reason to think that any different result would have happened if someone different had been there. The person who, in a sense, is the most trusted person as far as Mr Kei is concerned, is seeking to assist him in dealing with this, and it doesn't get off the ground at all. And the evidence that you've
So
seen...
who is the most trusted person?
Dr Choi.
I thought Dr. Choi himself said that the most trusted person is Mr. Wu.
Well, he's obviously not talking about himself. I mean, the Mr Wu is referred to at, I think, page 66. He's referred to as... he was referred to in the 2021 report where he came with Mr Wu, and as far as 2023 is concerned, pages 78 and 79 of the main, he's referred to as his best friend. They share snacks together, paragraph 22, and Mr Wu notices that he's feeling angry towards gossip about him and spreading media problems, also asking about anyone want to persecute him. So with respect, there's no reason to think that any better result would have been obtained in any other way. So that's what happened. Now, so far as
what was it about the meeting on the 22nd of February 22 that made Mr. Kei so comfortable to provide so much information to UBS?
Well, there is a big issue about this. I mean, I haven't told the court about it. I haven't sought to summarise the evidence. There is a lot of evidence about it. I suspect it will be very contentious. That we have put in several witness statements in response to the contempt as to about what happened in respect of these meetings. I can tell your lordship in summary what the position is.
Well, we have to look at the material that was before Mr. Justice Fox.
Well, that's why I haven't mentioned it.
All I asked you about was the document that was before Mr. Justice Fox.
Yes. Well, there was,
so
as your
on
lordship...
on the basis of the evidence before him, what was he wrong to take the view that evidence appeared to contradict Dr. Choi's conclusion?
Well, that would be one factor to take into account. On the other hand, when one has the question of the question as to whether he is capable of giving instruction to his lawyers and the balance of probability, and he's seen the evidence of Dr. Choi as of June 23, and Dr. Choi says this man can't do it for the following reasons he gives, then in our submission, then certainly it would be open to the judge hearing the contempt proceedings in March to take the view that notwithstanding Dr. Choi, this is all a complete fraud. That is perfectly open after cross-examination of the witnesses, Dr. Choi and the like. On the other hand, here, the one witness who's seen him 40 times, as your lordship knows, says this man has not got capacity because he's hallucinating and he thinks his lawyers are radically. And then you get the fresh evidence. Now, I learned a friend says it's not admissible and doesn't take anything anywhere. So can I just deal with that briefly? I'm in your lordship's hands. I'm going to be about another 15, 20 minutes, and whether you want to,
Yes, let's
I
just
thought you might just, exactly, fine.
Just before you come to the fresh evidence,
Yes.
since you were looking at the Act, Section 3.1
Yeah,
tells us what it is when a person's unable to make a decision for himself.
yes.
So I've got two questions. Is that an exhaustive explanation of what it is, of when a person's unable to make a decision for himself? And the second question is, which of those subparagraphs do you put Mr. Kei in?
I think 3.1 probably is. I mean, it's not an including. It looks as though it's a definition.
Yes.
I think it is. So understand the information. I think all four of those, but if you can't communicate with your lawyers because you think that they're going to kill you, well, possibly one comes under all four.
Thank you.
I think C is possibly the most important.
I'm not sure whether it is exhaustive. And under the previous Act and the previous law, Masterman, Lister and so on, one of the critical questions was, does the brain-damaged victim of an accident understand the need to take advice? Which doesn't seems
to
to
be
be
there, doesn't it?
covered here. And one could see. I would be
Your
surprised.
should be
I would
right.
be surprised if that sort of question were intended to be removed from the scope of capacity.
Well, I must say I hadn't until Lord Justice.
But it may not matter for the
No,
purposes
I mean,
of this case.
until my Lord had raised it, I have to say I hadn't considered the question. I mean, it may be, if you look at 3.2, that's is a sub-definition of 3.1, I think, isn't it? 3.1a. 3.3 is a sub-definition of B. 4 is a sub-definition of C. And yeah, I'm sorry, I can't.
Anyway, it may not matter.
Yeah, I don't think I can assist any more than that. Thank you. That's helpful. So, the learned friend's next submission was in relation to the fresh evidence. Now, it is obviously wasn't available in that sense before the Foxton order, and its importance. I mean, it was recognised by Lord Justice Mayles in giving leave. Indeed, as your Lordship sort of seen, Lord Justice Mayles wouldn't have given leave without it. So the claimants say it could have been produced earlier. First point here is that until the Foxton order, Mr Kei had the benefit of a litigation friend, and he had the benefit of Dr. Choi's previous report, which was used in 2021 to show he wasn't capacity. He also had friends to assist at every stage. What now happened, by contrast, is that there is an order which requires him personally to comply in terms of assets, potentially with a sanction of contempt. He has no person who is allowed to do it for him because the order required him to do it without an intermediary, and has to do it himself, as it were, and he therefore has to do something that has not and could not have been done before, and indeed that if one had tried to do it before, one would not have had something of that importance, if you like, because a failure to comply has the potential of contempt. So it is quite different from anything that had to be done before. In terms of its effect, what Mr. Justice Foxton held, or the judge held, was that notwithstanding Dr. Choi's 2023 report, he was not satisfied in the sense that I think that the decision is effectively that the evidence doesn't go far enough to decide on the balance of probabilities. So when one then one tries to comply, and I think as what was put by my lords is first of all it is relevant because it provides corroboration to Dr. Choi in an important way. What was feared has come to pass. But just picking up my Lord Justice Popplewell's comments on dissembling, given that and I think Mr. Justice Foxton's order is consistent with not having to take a view about dissembling, because he was simply saying on the balance of probability not sufficient to prove. However, once one gets the further evidence, it is very hard to see how that could be consistent with anything. I mean, either it shows it's very hard to see how that is consistent with anything other than either one, lack of capacity, or two, dissembling by Mr. Kei in a way which has, as it were, persuaded not only, Dr. Choi, Mr. Lin Hu, and anybody else.
Well, it's also consistent with the fact that interviewing him over a video link may not be the best way to do it.
Well, my lord, with great respect, he wasn't interviewed with a view to putting in fresh evidence. He was interviewed with a view to complying with the order. The order simply says comply with the order. We did our best. Your Lordship has sought to put forward a whole bunch of possibilities as what else might have happened. You know, what was done was going beyond anything we were asked to do, or with a view to trying to maximise the possibility. That the view was taken that that was the best way, and you know, you could have 20 other people, one of whom might have helped, but that actually might have been counterproductive. It's Dr. Choi who's important in respect of this. He is the man who sees him regularly, and if anyone's going to persuade him, one might have thought that he was. And with great respect, it's not fair to say, well, something else could have been done in those circumstances. Anyway, that's, your Lordship will have to take a view on that. But in our submission, that really is, you know, we haven't, if we had had Lin Hu and Mr Kei alone, then one would see the force in what your Lordship's putting to me. But when you've actually got the psychiatrist who has earned his trust every period of time there, trying to make this work.
I don't read it as suggesting that Dr. Choi was in the room.
I don't know the answer, and I.
Well, why does it say he came onto camera and immediately recognised Dr. Choi if Dr. Choi was already in the room?
Well, I don't know the answer, and Lin Hu is not in court today, I'm afraid. Otherwise, I'd ask him. There is, I think. Otherwise, if he was here, I could simply ask him the question, and he could give an answer.
We just have to read what's on the page.
Well, yes, of course, your Lordship is right, but.
Am I reading it incorrectly?
Well,
do you suggest there's a reading here that suggests that Dr. Choi was in the room? Because it seems to me fairly clearly from what's said that he wasn't.
I certainly don't think it's clear. So there was an appointment. So he's trying to arrange a meeting. So if you look at paragraph 13.
Can you remind me the page?
I'm so sorry, 59.
Thank you.
Well, that is, I had certainly read that as saying, as little 2, as meaning that Dr. Choi was there. Because that's what it appears to say. Now, it is perfectly possible that...
That's in paragraph 13 suggests that Dr. Choi was asked to attend the meeting.
Yeah.
And it was at least in part a video conference.
Exactly. I mean, I know, I understand why your Lordship puts to me that it's not clear, because it could be the position that the meeting was a video meeting, and therefore it is possible that Dr. Choi was there on a camera. I can see, and that's the point your Lordship's putting to me, and I can see that is possible. I had certainly read that as Lin Hu saying that Dr. Choi was going to be there to assist, and the idea of reassuring and calming him and facilitating him is much more likely to have happened, one would have thought, if Dr. Choi was there. So that was what he was asked to do. He was asked to explain it before, and then recognising Dr. Choi, he's got his assistants there and asked Dr. Choi what Dr. Choi wants him for. So, I mean, this is also consistent with the camera taking place presumably in Dr. Choi's surgery.
I've written down your submission that Dr. Choi reassuring him and calming him would have been much more likely to be effective.
Well,
had he been present, is that?
I mean, I'm sorry. I mean, if necessary, we can contact Lin Hu and I can get instructions with a view to it being confirmed.
We don't know where Mr. Kei was.
Look, all I can do is show you those paragraphs.
Yes.
I had understood it, and it may be my fault, as being from the attend the meeting and to assist that Dr. Choi was there. If your Lordship wants me to get instructions from Lin Hu, who's not in court unfortunately today, as to what the position was, with an undertaking to confirm that in a witness statement, I'm very happy to do so. I don't know. I don't think he's in the jurisdiction, so I don't know where I can do it.
It's your application to produce fresh evidence.
Well, of course.
I think the point I was simply making was that you put to us two very stark possibilities. You said that what this evidence demonstrates is either a lack of capacity or dissembling, and all I was suggesting to you was there might be a third possibility, which was that the remedial measures that Mr. Justice Foxton had in mind were not in place.
Well, he didn't mention anything of this, of course. And when he talked about remedial measures, he simply makes the point that in the June report,
Yes.
Dr. Choi doesn't refer to any. So that's what Mr. Justice Foxton had in mind.
Well, I think Mr. Justice Foxton's conclusion was that the suggestion that he lacked capacity, even with the benefits of such remedial measures as might be put into place. I think the only point I'm making is, it doesn't seem to me, I can't at the moment identify that any remedial measures were taken.
Well, the remedial measure, I mean, so what the issue one's looking at is whether he had capacity to take decisions in relation to the litigation
Yes.
on his own.
Yes.
And that's I'm struggling to understand how you can if you are hallucinating and think your lawyers are trying to kill you and you won't engage with them at all, how you can possibly do that. But that's obviously a matter for your lordships.
But your submission is that this involved all the reasonable measures that could reasonably be expected by having Dr. Choi participate, by having the assistants there, who you say must or probably included Mr. Wu, and doing it in this way.
And if it would assist the court, I mean, my lord says, well, it's our application, it's a matter for our evidence. I have to say it had not occurred to me until my lord put it that there was any ambiguity about whether Dr. Choi is there. Having made the point, I understand the point that your lordship's making, and all I can say in respect of that is if the court would like, and obviously it depends on whether you intend to get judgment straight away or reserve, but if the court wishes me to get instructions, I don't know, I think Mr. Lin Hu is in a different jurisdiction, and therefore I don't know whether he can be contacted immediately. But if it would assist the court to have a witness statement confirming that, I'm sure we can do that by tomorrow.
Well, I think you should take it, that's not an invitation that's coming from the court.
Right. So be it. Anyway, I've so the in our submission this is different, and I know my Lord Justice Popplewell explored the point with a learned friend in some detail, because it's very hard to see how that can be consistent with either lack of capacity or dissembling, and to that extent is different from the position in relation to the evidence before Mr. Justice Foxton. So, learned friend then seeks to argue and show the court the documents relied upon in the contempt proceedings to show the strength of the case on contempt. Now, I've made it clear to the court. I've not referred to it.
I don't think that was the purpose of showing us the document. It wasn't to show the strength of the case on contempt.
Well, it was to show.
It was to identify the documents on which
Yes, I
Justice Foxton
wasn't saying critically at all. He's shown you the documents. I've made it clear that I haven't referred to the explanations that have been given in the evidence, and it wouldn't be appropriate for me to do so because they are all in witness statements that have now been served that were not before Mr. Justice Foxton. However, and I've no doubt that the explanations that I've given will be contentious so far as the hearings enlarge. There are explanations now before the court, but so be it. There obviously wasn't at the time of the hearing before Mr. Justice Foxton. These will be major issues in respect of March. But even if one takes the view that there were strong grounds for the complaint, if you like, and for the contempt allegation, one might think that emphasises the importance from Mr. Kei's point of view of a fair trial, and that decisions need to be taken objectively on his behalf, and how important it is in something of a seriousness as contempt in the decisions being made objectively. And I do say that in the light of the fact that, I mean, how the contortions that Dr. Choi would have to go through to be, when he was shown those documents, and the documents relied on by my learned friend, and said, well, you mustn't assume that they are necessarily the case, but what are your comments in the light of your knowledge? I would respectfully suggest that has the potential to embarrass an independent expert on facts that are potentially contentious, that are outside his knowledge. But anyway, your lordships have my submission in respect of that. But finally, I mean, I just ask this rhetorically. You've seen what happened. There is an order of the judge which requires us to put in an affidavit of assets personally. We tried and we failed, and your lordships have seen that. And I ask rhetorically, on this important matter, what are we supposed to do in relation to that? I mean, potentially, if we don't have a litigation friend, there is the potential problem of contempt. There are going to be all sorts of problems in the conduct of this. But your lordships have my submissions on that, unless anything further I can assist you with.
Thank you very much. First of all, I probably owe an apology for mispronouncing a number of the names.
I've tried to keep it to a
Mr.
minimum.
Kei and Mr. Hua.
Yeah, I try and keep it to a minimum by referring to his wife and his brother-in-law.
Yes.
And it's a bit of an art to that. But I'm sure,
Anyway,
no one's offended.
That's what I wanted to ensure that no offence was intended. We'll take time to consider our judgments. They'll be handed down in draft in the usual way. You know the form, editorial corrections only, not an opportunity to re-argue the case, and the embargo is to be strictly observed, and if not strictly observed, there are sanctions which might involve contempt of court. We'll expect you to seek to agree an order dealing with consequential matters. If you can't agree, submissions in writing, and when the judgment comes to be handed down, there'll be no need for any attendance. It'll be handed down remotely in the usual way. Thank you all very much.